Today I will be talking about the American case Ellison and Robertson, with emphasis placed on safe harbours. Harlan Ellison is an author. Stephen Robertson posted unauthorised digital copies of his novel to Usenet, a newsgroup that AOL made available to their subscribers. Ellison sued Robertson for direct infringement and settled for $3,650. Ellison sued AOL for direct, contributory and vicarious copyright infringement. In the district court, it was found that they were not directly liable, and Ellison didn't pursue this any further. It was also ruled that AOL might be liable for contributory infringement but was protected by the Digital Millennium Copyright Act safe harbor. It was also found that they were not liable for vicarious copyright infringement. At the appellate court's proceedings, the judge agreed with the district court that AOL could not be held liable for vicarious copyright, but could be held liable for contributory copyright infringements. Therefore, they sought the protection from safe harbours. A copyright safe harbour may protect ISPs and content hosts from monetary damages, with the only remedy available limited injunctive relief. But they must meet certain conditions. In this case, there were two issues. 1. Did AOL function as a conduit service provider under Category A? And 2. Did AOL reasonably implement a policy against repeat infringers? To answer the first issue, the following questions were asked. 1. Was the 14-day period during which AOL stored and retained the infringing material transient and intermediate within the meaning of 512A? And 2. Was no copy maintained on the system or network for a longer period than is reasonably necessary for the transmission, routing, or provision of connections? The district court judge had answered yes to both these questions and relied upon the judgment in Netcom to afford AOL the protection of safe harbours. The appellate court agreed that AOL is eligible for the safe harbour limitation of liability under Section 512A. But to be eligible for any of the four safe harbour limitations of liability, a service provider must meet the conditions for eligibility set forth in Section 512I. The safe harbour limitations of liability will only apply to a service provider which A. adopts and reasonably implements a policy which addresses and terminates users who are found to be repeat infringers, and B. accommodates and does not interfere with standard technical measures. Now, AOL did have a policy against repeat infringers, but they changed their email address in late 1999 and failed to notify the Copyright Office of the change until April 2000. And according to the appellate court judge, AOL should have closed the old email account or forwarded the emails sent to the old account to the new one. Instead, AOL allowed notices of potential copyright infringement to fall into a vacuum, and that fact was sufficient for a reasonable jury to conclude that AOL had not reasonably implemented its policy against repeat infringers. Therefore, AOL was not protected by the safe harbour limitations, and the judge sent it to trial. In 2004, AOL settled with Ellison for an undisclosed sum. Thank you.